rise. The Court of Appeals Division 1 is now in session.
Please be seated. Good morning. Today is June 12th, 2025. This is the time set for oral argument in our case number CACV240615, Tom Horne versus Katie Hobbs et al. Out of respect for counsel and to avoid any embarrassment for anyone in attendance in the courtroom, please make sure that your cell phone is on silent. Each side is allocated 20 minutes for oral argument. Although you're not required to use all of your time, if appellant wishes to reserve a portion of that time for rebuttal, you are free to do so, but you need to keep track of your own time at the podium. The clock on the podium reflects your total remaining minutes. These proceedings are being live streamed and will be available on our website for viewing. With that in mind, please make sure to speak into the microphone when you're presenting and to introduce yourself. Please keep in mind that we have read the briefs, studied the record, and discussed the case in conference, so please keep that in mind as you present your case. You may proceed.
Thank you, Your Honor. I would like to reserve some time. I'm here, Dennis Wolinchek, on behalf of Tom Horne, Superintendent of Schools. I wanted to start, I'll be brief, but I wanted to start by pointing out that the voters had their say, that all children in Arizona public schools should be taught English by being taught in English, and all children should be placed in English language classrooms, which requires an immersive process. That was codified into 15752, as you know. And because Prop 203, which generated the statute, is a citizens' initiative, and neither the legislature nor the governor nor anyone else, frankly, can abrogate it or amend its purpose. Arizona Constitution, Article 4, Part 1, Section 1, 6C, makes that point clear. A voter-initiated proposition that becomes law, the legislature has no power to amend or to abrogate or to distort what the voters by a supermajority stated. Now, bottom line is, I said I keep brief, but to summarize, the 2019 legislation, we contend, would be a violation of the Constitution if, in fact, my learned colleague's position is taken as correct. And similarly, as to the governor, under Section 1(6)A of the Constitution, the veto power of the governor shall not extend to initiatives and referendums approved by a majority of the votes cast therein. Now, I don't think that anyone really has contested a lot of that. What they have done is argued standing, authority, and those kinds of issues. Now, as to standing, I'll hit these issues quickly and then entertain any questions if you have. An official who could be violating the Constitution and face expulsion from office and suffer loss of funds clearly has sufficient standing to challenge the law the official is required to enforce. And we've cited the U.S. Supreme Court Allen case in our briefing, stating that. This Sears case, which my opponents cited, Arizona Supreme Court case, similarly discusses standing. In that case, they discussed even possibly vitiating the standing altogether, which the Supreme Court had the power to do. But the Supreme Court there made some interesting comments about standing that I'd like to repeat. Basically, they discussed standing in the context of avoiding advisory opinions and by having true adversaries. I think this case, clearly with respect to everyone, has true adversaries. And all of this is true of the superintendent under ARS 15754.
Well, let's start there. We'll start with true adversaries. The governor does not have the authority to promulgate these. Yeah. She doesn't, right?
Yeah, I was going to come to that, but yes.
Oh, no, well, we'll stay, since I want to ask these questions. Okay, and the AG does not have the authority to
That's
promulgate
correct.
these. And in fact, the school districts that you've sued don't have the authority to promulgate them. They have to use that which has been adopted by the board. Right?
That is partly correct.
They can go out and create their own?
Huh?
Or they can go out, and I'm speaking loudly because I know you're having a hard time hearing me.
Well,
I'm not angry, I'm just speaking loudly. But the districts have to use what the board has promulgated.
well, let me answer that, please. Because I think that's a misconception in all candor. And I think the lower court suffered from the same misconception of what our case is and what our point is. Any person implementing a violation of law or a challenge procedure is a proper defendant under the Arizona Republican Party versus Richer case that the Supreme Court ruled on in 2024. Judge Brown was involved in that case. I was involved in that case. In Richer, the defendant county officials argued they were doing their job by following the dictates of the Secretary of State, similar to what the court has asked me. Just like the defendant school districts here are arguing, they are doing their job by following the Board of Education.
Mr. Horne, can you cite to me any statutory authority that the school districts would have to promulgate their own programs?
It has nothing to do with that, Your Honor. That's what I'm trying to explain.
Well,
this has nothing to do with them promulgating anything. It has to do with them...
Didn't the board adopt this 50-50 program?
Yes, and we're claiming that no one has the authority to vitiate or change or amend and the will of the people, and that's the whole point. So, with all due respect, it's not a question of who's promulgating anything. It's whether or not they're following the law and whether or not Mr. Horne has the right to challenge the fact that they're not. And as I was saying, in the Richer case, it was the same argument. The Arizona Supreme Court held the county officials were nonetheless proper defendants because they were implementing a violation of the law, which is different than what you're asking me. So that's why I said it's partly true because, yes, in some respects, what you're saying and what the lower court said was correct, and what they're saying is correct, but it has nothing to do with the issue, ultimately, of whether or not, under the Declaratory Relief Act, we can seek relief for the fact that they're not implementing the law, and that's the issue.
Well, except the people that adopted these plans is the board.
But it's not relevant who adopted it.
They adopted the plans, and you're saying that adoption violated the law. And they're not here to... Well, I'm going to ask the question.
Well, okay.
They're not here to defend the adoption of those plans, are they?
If they adopted that, one of the issues in this case is whether they adopted anything and whether they adopted anything that is in violation of the law. They have said, we are not interested in this litigation except in the outcome. They're not saying they adopted a dual language program. They're saying they were following state law as well. Whether they were properly doing so and can do so is the issue. That is the issue. It has nothing to do with this tangent that they let everybody down on, in which, with all due respect, the court is going down on, at all. It has to do with a very simple point. If they are implementing a law, any of them, and it is contrary to the will of the people under the Constitution of Arizona, they simply cannot do it. And Mr. Horne is standing, he's being affected by it directly. Under the Uniform Declaratory Relief Act, it says any person may bring it. That is the statutory authority, and it's as simple as that. And you ask about the governor. The governor is the chief law enforcement officer of the state. That's been established in, I think it was the Prop 200 case.
No, that would be the Attorney General, so the chief law enforcement officer of the state.
Well, okay. It says that I believe that the governor is the chief person administering the laws of the state. I don't know the exact wording, but that's the gist of it. But moreover, she's actively advocating, again, for an implementation that is in violation of the law, the Constitution.
But counsel, what act has she taken to implement the law?
Well, we pointed that out, but she's taken public stands and statements.
Okay, public statements. again, she's a politician. She says all kinds of things. Your client says all kinds of things.
But she's also the governor of our state.
I'm asking, what official governmental action has she taken to implement the law?
I don't know of any official action to answer your question, Your Honor, but I don't know, honestly, that that's relevant under the case law that I've looked at, whether it's an official government action or not. She is advocating out there, and I believe because she's the governor, people can understand that she is advocating in a role as governor. I don't know if there's any official act she signed, but we can debate that issue of whether, if she's the governor, she's out there not disclaiming that she's the governor. She's not saying, I'm doing this personally. I think she's doing that in a role as a governor.
And what official action are you alleging that the Attorney General has taken? I think I know the answer to the question.
Well, again, we can debate this argument about official action, but the only acts that we've alleged are the Attorney General's opinion, which, again, we are not trying to debate or undo her opinion. We can't do that. We get that. We've always gotten that. But what we're suggesting is that if somebody is out there in a government position such as that, advocating for a violation of the voter initiative, under the Constitution, simply they can't do that. And then the next question is, who's enforcing it? No one. So there's lawlessness. There's a law that's not being followed. No one is doing anything about it. Parents are apparently afraid to bring actions, whatever reasons, I can't speculate. But Superintendent Horne, under his official duties, has certain obligations. And part of those are to ensure
that the school districts are in compliance.
I'm sorry?
That the school districts are in compliance.
Yes, that's correct.
Okay. And so if he believes that these plans are not in compliance with state law, he can tell the school districts, you're not in compliance and you have a corrective action plan.
That's one option, and I think he has done that.
And then a year later, if they haven't rectified the situation, he can then refer that to the board.
He could.
And say, punish them for not complying with the law.
Correct.
And then it's the board that has to take the official action.
Well, that's where we may differ, Your Honor, with all due respect.
Okay.
The board may take action, but obviously the whole point of why we're here today is the board has chosen not to take any action and instead said to the superintendent, if you go forward with this, we'll abide by any decision. And that's in our complaint, and this is a motion to dismiss, and that should be presumed to be a true statement. And that's the position of the board. That's why they haven't taken any action at this point. They're awaiting to see what the ruling is as to whether or not this is in violation of the Constitution to establish this dual language immersion program as opposed to the program the public sought to have initiated.
So what you're telling me is the board wants an advisory opinion?
No, the board wants an opinion.
That's what it sounds like.
I didn't say that. You said that. I didn't say that. The board doesn't. No, I'm not advocating that at all. What I'm saying is the board will abide the decision of this court on an actual case or controversy, which we have right now. It's just someone is violating the law, and there's lawlessness, and no one is doing anything about it. And the superintendent feels, pursuant to his position, that he has to do something because the board has chosen to simply wait and see what he does. That's where we are, factually. So I don't think they're just seeking an advisory opinion. There's a real case or controversy here. I mean, if you look at, the basis for what an advisory opinion is, I don't think this fits anything close to an advisory opinion. We've got actual issues going on right now where they are directly violating what not only the proposition said, but what the law says. And we got a situation under 754 where my client, clearly under Allen, has standing to complain because he could be directly thrown out of office and have monetary penalties if this continues on, arguably. And that's one of the things we seek declaration on.
Doesn't he only get that penalty if he willfully disobeys the law?
Sure.
And I mean, from everything you're representing here, there's no willful violation.
Obviously, everything I'm representing is not...
Excuse me, let me finish. I think that under the statutory scheme, my understanding is that his responsibility is to make sure that the districts, do their job and report back. If they don't do that, then he ultimately, after some time, refers them to the board for some action. So if he's doing his job under the statute, how would he be willfully disobeying the law?
Well, with all due respect to the court, that's one of the issues we seek to find out under the declaration, because, again, that's the position you're taking right now or positing. It may be right, it may be wrong. I don't know. I've read that 754, and I don't know what willfully means at all. I would take the position right now, which is why we're seeking to have declaratory relief, to get clarity, that if he doesn't do anything, that it's not willful, in which case his standing issue would be diminished, certainly. But we don't have that ruling, and that's why we're here. So I hope that helps.
It does help. I have another question in regards to standing. Our Supreme Court has addressed other cases like this before, where we have elected officials on opposite sides of the aisle here. And specifically in Brewer versus Burns, our court said that they had concern over standing is particularly acute when this court is asked, in effect, to referee disputes between political branches. And they cited Bennett versus Napolitano. Obviously, this is the same branch, not different branches. But how are we not in a situation where you're asking this court, or the courts in general, to referee this dispute amongst elected officials?
Well, that's a good question, but the best I can honestly answer it is of a concern, certainly. I would agree with the court, but it doesn't preclude under the Declaratory Relief Act from Mr. Horne bringing the action. And if it did, I think the Declaratory Relief Act or some other statute alongside of it would say so. And there's nothing preventing him from being a party litigant under the Act. That's why we're here. I don't think the court below cited anything that specifically provided that. The court instead flipped it on its lid and said there was nothing actually saying he can do it, but there's nothing saying he can't. And I appreciate the concern the court had in saying that, and it's a real concern. But I think here the issue has to do with a real legal, purely legal issue. It has nothing to do with politics in that sense, at least from our standpoint. It has to do with whether or not the law is being complied with and whether or not he can enforce that law as a citizen who is not only directly affected but has other duties, which I won't waste time on, but obviously you're familiar with, including the duty that the court, Judge Murray said, and the fact that someone can bring an action against him, whether we like it or not, and claim it's willful disobedience by him not doing anything that he should be doing.
And I understand that. So you just mentioned his, position bringing this as a citizen, but he hasn't brought it as a citizen.
No, that's correct.
He brought it as the superintendent.
You're correct.
So I want to turn a little bit to your argument about his authority to bring suit. Obviously, your opposing counsel is claiming there's no authority. Can you hit on that a little bit?
Yeah, as I said really quickly, the authority is found in the Declaratory Relief Statute, as I said. It provides any person, whether he's superintendent or any other official position. There's nothing I've seen that precludes him from access to the statute.
So in terms of any state employee at any time can bring an action saying that their boss is violating a statute and the statute's unconstitutional.
Well, that's not what I said, of course, but what I said is that they have to establish the modicum of standing, which means, that they are a true adversary and that they are going to proceed on a case because of a reason. The reason here is found in 754, which may not apply to every state employee.
Okay, thank you.
I'd like to reserve some time if that's okay. Mm-hmm. Thank you.
Before we get started, Council, are you guys going to be splitting time?
Yes.
Okay, thank you.
Good morning. May it please the court. My name is Nathan Arrowsmith on behalf of Attorney General Chris Mays. As you just alluded to, Judge Foster, we are going to be splitting time. There's quite a few parties on this side of the V. I'm planning to speak to you for about 10 minutes. You'll hear from my colleague, Austin Yost, who will address why Governor Hobbs is not a proper defendant. And then you'll hear from my colleague, Chaz Workin, about why the school districts are not proper defendants.
Thank you.
I'm planning to address everything else. I will keep an eye on the time. I want to, sort of direct the court's attention back to the complaint in this matter. I think we heard a lot of things from my colleague, Mr. Willencheck, during his argument, and I think it's important to look back to the complaint. Mr. Willencheck talked a lot about the superintendent being subject to suit under ARS 15754, and the complaint is at Appendix 26 through 36, 25 through 36, and it's at IR 39. Talked about the superintendent being subject to suit under ARS 15754. There is nothing, no allegations in the complaint about that. He hasn't alleged that any parent has threatened him with a lawsuit. There's nothing from which the Superior Court could conclude that that was even possible. That's a post hoc rationalization that has come up in the course of briefing. He hasn't alleged anything about changing his behavior because of a concern about 15754. He also made some allegations about the board declining to act. This came up at the Superior Court. There's one allegation that says it has been conveyed to the superintendent that the state board will not act in regard to this issue. That's paragraph 32. The Superior Court is not required to accept it as true, an allegation that's demonstrably false. The court can take judicial notice of the board's minutes for the past 2 years. The board has not voted to take a position on this lawsuit. So the Superior Court was not required to accept that allegation. That's the only allegation in the complaint about the board. Mr. Willencheck also referenced something about the governor and having sort of exercising veto power over a citizens initiative. There's only one allegation about the governor, and that's, I think, in the parties and jurisdiction section, and it just quotes something that Governor Hobbs said after this lawsuit was filed. Also, I want to address, Mr. Willencheck was talking about the superintendent being required to certify a violation of the law. There are also no allegations in the complaint about that. There's no allegations that the superintendent has done any of the things under 15756.08 that he is directed to do, that he has engaged in any of the monitoring. So I'm not sure where that argument comes from, that he's being required to do anything. It's certainly not in the complaint. I also, the court correctly noted the superintendent has sued in his official capacity and not as a citizen. So with respect to the Declaratory Judgment Act and whether there's standing under the Declaratory Judgment Act, a critical component of that, I heard my colleague say, true adversaries. That means more than just that you have a disagreement about what something means. You have to have an actual stake in the outcome. It has to be, when the court says that there has to be, true adversaries, a true controversy, it means more than just two, elected officials who disagree about something.
Well, let's look at the language of the statute. It says any person can bring or can seek declaratory relief whose rights, status, or other legal relations are affected by a statute. It sounds a little bit different to me than what you're saying. So help me understand that. What's wrong with Mr. Willencheck's argument?
Sure.
That his client has been affected by this?
Well, so, Your Honor, the statute, and again, looking to the complaint and the request for relief, the superintendent asks the Superior Court to declare that 15756.01 is unconstitutional to the extent that it allows dual language. So that's the statute that we need to look at to determine whether the superintendent has any rights, status, or legal relations under that statute. And that statute doesn't mention the superintendent at all. That statute directs the state board to adopt, let's see, just pulling it up here. Directs the state board to adopt research-based models of, adopt and approve research-based models of structured English immersion for school districts and charter schools to use. So it doesn't mention the superintendent at all. It doesn't give him any rights or assign him any status.
So your contention is he's not affected because he doesn't have an interest in that statute?
Yes, he's asking you to declare a statute unconstitutional that he has no interest in. But an important component is that you have to also sue someone who can, do something about the relief that you seek. You can't, he couldn't sue the, state mine inspector and say, I want this statute to be declared unconstitutional. There has to be some connection between the parties with respect to the statute, and that goes to the legal relations. There is no legal relationship with, the superintendent and the governor and the superintendent and the attorney general as to the statute. The statute does mention that school districts, and this one goes to a question you asked, Judge McMurdy, school districts can submit their own models to the board for approval. So it does say in 1575601C that school districts can submit models to the board for approval. But again, it doesn't mention the superintendent.
But they didn't do that in this case, correct? These districts didn't.
They did not, no. They are the districts, and again, returning to the complaint, there's only an allegation about, paragraph 31 says, defendant Creighton Elementary School District, among others, is permitting dual language instruction for English language learners. There aren't any allegations about the other school districts, but the school districts are adopting or implementing, among other SEI models. School districts can choose from any of the models approved by the board. They don't have to choose just one. Different schools within a school district can choose different models. So school districts are implementing the 50-50 model as one of the options for
Okay,
English
and
immersion.
maybe this question is reserved for Mr. Workin, but the districts in this case adopted models promulgated by the board or adopted by the board.
They're implementing a model approved by the board. And I did hear Mr. Willenchek say something about he wasn't sure whether they had adopted it. They do say in the complaint that it was adopted by the board, so I'm not sure where that comes from. That's certainly not in the complaint or in any of the papers, any sort of dispute about whether it was properly adopted. So returning to our conversation about the Declaratory Judgments Act, you do have to sue someone who can do something about the problem that you allege. And so the issue that we have here is that there's no legal relationship between these parties with respect to the statute that he asks you to declare unconstitutional. And I want to briefly touch on, I'm not sure that it requires much time. The only relief that the superintendent seeks against the Attorney General is to have her opinion declared legal error. That's not a justiciable question. This court has held that before, that Attorney General opinions are not binding. You can't sue the Attorney General to have her opinion declared legal error. And that is, in fact, in the request for relief, they've asked the court to declare that the Attorney General's opinion is legal error. That's not a justiciable question. There isn't any other relief sought against the Attorney General. There isn't any relief sought against the governor either, and there, in fact, isn't any relief sought against the school districts. He's asked, for a declaration about the statute and about the DLI model, but he didn't ask, for example, for the court to order the school districts to stop implementing it. So this really, I think, goes to the point that you were making, Judge Foster, about what our Supreme Court has said in Bennett and in Brewer about standing being extremely important in disputes or lawsuits between elected officials. The court needs to make sure that it is an actual controversy, that there is a real dispute with, where the parties are legally interested in the dispute, to avoid becoming a referee for, two elected officials who disagree about something.
Mr. Aerosmith, I have a question about attorney's fees.
Sure.
You requested attorney's fees, but you did it late. And you said, we agree with the governor, but the governor wasn't asking for fees for you. The governor was asking fees for herself. So the way I read this record is you never asked for fees for the Attorney General properly. How do you get there? How does the court award fees when you didn't ask for it properly under Rule 54?
I think I understand the point you're making. So, Your Honor, I think we filed a joinder saying that we join in the request for fees. We are requesting fees. And
No, you didn't say that. You said we are joining with the governor's request for fees, which was for herself.
Okay. Well, I think that the Superior Court has some discretion to determine whether the request under 54G is proper. And I think the most important point there is that the purpose of 54G was effectuated. The superintendent was on notice, well in advance that everybody was seeking fees. He didn't raise the issue until after the Superior Court had dismissed his complaint and after the fee applications had started. So he was on notice that the Attorney General and the school districts and the governor were all seeking fees. And I have gone over my time. I want to, unless there are any other questions for me, pass things on to Mr. Yost. Thank you.
Good morning, and may it please the court. My name is Austin Yost, and I represent Governor Katie Hobbs. As we noted in our briefing, we join the Attorney General's and the school district's arguments on the superintendent's lack of authority and standing to sue. But in any event, if this case returns to the Superior Court for any reason, this court should still affirm the dismissal of the claim against the governor. I'm going to echo a legal principle that we've just heard from counsel for the Attorney General, which is that under the Declaratory Judgments Act, there must be an actual controversy between interested parties. The superintendent's claim against the governor does not meet that standard. The Superior Court rightly recognized that the governor has no role in implementing Prop 203. This is, I think, perhaps most evident from the complaint's requested relief. Nowhere is the governor mentioned in any of the 4 requested declarations. Mr. Wilenchek talked about the importance of not issuing advisory opinions, and I think it's telling that he seeks no opinion about the governor's conduct at all. He argues that the governor is a proper defendant because he seeks a declaration that the state board's dual language model violates Prop 203. But the governor's not an interested party for that requested relief. This court addressed what makes someone an interested party just last year in Arizona Creditors Bar Association. In paragraph 21, this court asked whether granting or denying the requested declaratory relief would advantage or disadvantage a named defendant. If it would, then that would make the defendant an interested party, and if not, then not. Here, no matter whether the court grants or denies the requested declaratory judgment, the governor will be in exactly the same position as she's in today. She has no authority to adopt or approve structured English immersion models, and critically, she has no authority to change or delete them. So issuing the declaratory judgment that the superintendent asked for doesn't affect her right status or legal relations at all. She's not an interested party. Only the state board has authority to do what he's seeking. To try to get around that problem, the superintendent alleges that the governor publicly touts and stands by dual language programs. But of course, as Judge Foster recognized, in elected officials' public statements, expression of her policy preferences doesn't make her an interested party under this court's analysis in Arizona Creditors Bar Association. The superintendent can't sue an elected official because she's expressed preferences when really at the core of his claim it's that somebody else is violating the law. He relies on this court's decision in Yes on Prop 200, but that decision doesn't make the governor a proper defendant here for 2 reasons. First, Yes on Prop 200 is distinguishable both on the governor's conduct and on the entities involved. And second, Yes on Prop 200 was issued in 2007, and in the 18 years since then, I'm unaware of any court adopting the broad reading that he's urging this court to adopt today. So I'll start first with Yes on Prop 200. A little bit of background. The voters approved an initiative that required state and local agencies who administer state and local public benefits to run immigration checks and to report violations to the federal authorities. The Attorney General issued an opinion that narrowly construed state and local public benefits, and then the governor issued an executive order commanding that the executive agencies follow the Attorney General's opinion. So there, unlike here, the governor affirmatively did something. She involved herself in the implementation of the initiative, and that was critical to the court's analysis. If you look in paragraph 38, the court cites the allegations in the complaint in Yes on Prop 200 that it found sufficient to state a claim against the governor. The plaintiffs there alleged the governor is responsible for implementing Prop 200. The Attorney General has issued this opinion, and agencies are following the opinion as ordered by the governor, and then they allege that the opinion was wrong. The complaint here is nothing like that complaint. The plaintiff doesn't allege that the governor is responsible for implementing Prop 203. He can't because she's not. It doesn't allege that any state agency whose director serves at her pleasure is following an attorney general opinion because she hasn't ordered them to do anything like that. So as Judge Foster and Judge McMurdy recognized, here, unlike there's no official action from the governor that would make her an interested party under this court's analysis in Arizona Creditors Bar Association. It's also telling, I think, that the entities involved were different. Here we're talking about the state board, which is a constitutionally created body exercising its own constitutional authority, whereas there we were talking about state agencies who had a single director serving at the pleasure of the governor. And so I don't think yes on Prop 200 under any reading justifies keeping the governor in this case. There are good reasons for interpreting yes on Prop 200 much more narrowly than the superintendent asks. Think about the floodgates of litigation that would open against the governor were the superintendent right. Suppose somebody issued a public records request and they were upset with how the agency handled it, or they were upset about prison conditions in their cell, and they're just going to bring declaratory judgment actions against the governor on the theory that she could have removed the director and appointed somebody else who would have evaluated these things differently. There's nothing in the Declaratory Judgments Act that suggests that that's what the legislature intended when it enacted the statute, and there's no case that I'm aware of that would support such a broad and reading that I think produces massive absurd results. The better rules in Arizona Creditors Bar Association, there must be an actual controversy between interested parties, and no such controversy exists here. Happy to answer any questions. Otherwise, thank you, Your Honors.
Thank you.
Good morning again, and may it please the court. I'm Chaz Workin. I represent the various school districts in this case. I'll be brief, and I won't belabor the issue of the impropriety of the joinder of the districts as parties, because I think that's well appreciated by Judge McMurdy and no doubt the rest of you. But with regard to attorney's fees, the purpose of Rule 54G1 is to give notice of a claim for fees to enable the opposing party to possibly avoid the risk of an award of fees by settlement. That rule, of course, has to be construed to do justice. And while you or I might have done something different than the joinder in the request for fees,
It wasn't very articulate, I have to admit.
That's probably an understatement. I think you would have done.
I'm trying to be diplomatic, okay? We might have done it more perfectly, but we shouldn't honor form over substance. And certainly that joinder gave notice that there was going to be a claim for fees if the districts prevailed. And that notice was given well before Horne's response to the motion to dismiss was due, certainly in time to serve the purpose of the rule. And there's been no suggestion that there's any prejudice to Mr. Horne because of this imperfection in the request for fees.
Are they mandatory? Are fees mandatory in that situation?
I think the request for...
If they're mandatory, does Rule 54 even apply?
Well, I think the statute that applies is 12348 regarding disputes between government entities, and I do believe it's mandatory. Whether 54G then is kind of beside the point. I'd not thought of that before.
I don't believe anybody's argued that, but that was of concern to me when I was reading through this.
And of course, the fact that the statute is mandatory, again, underscores the need to be generous, if you will, and just in interpreting 54G1 and the compliance with it here. So that's all that I have. Thank you again for the conversation.
Thank you.
Thank you. In the little time I have left, I'd like to hit a couple of quick points that I didn't mention earlier. in response. I'd call the court's attention to 15756.13, which says nothing in sections 15756 and 5601 through 56.12 relieves a school district or charter school of its responsibility to comply with all state and federal laws. That's right in those statutes. So beyond the Constitution, the statutes themselves point that out. Horne is clearly affected by the outcome here based on his position, his unique position. Under 15754, the superintendent's liability is a purely legal question, not a factual one that needs to be alleged in the complaint. Next, just because Superintendent Horne can report to the board doesn't mean that's an exclusive remedy that he cannot seek other relief. Next, the Attorney General was brought in based on Judge Snow's opinion in 2011, based on the issue of whether there's an unconstitutional issue based on their position. That's why the Attorney General was brought in. I understand the statute was changed the year earlier, but Judge Snow's opinion came after that, so I don't know what to make of that.
We regularly disagree with our federal counterparts.
Yeah, right. Anyway, next, requesting injunctive relief or that the school district stop is in no way a prerequisite to seeking declaratory relief. There's no authority for that. Next, Proposition 200 case. It says it's not necessary for the governor to be involved in necessarily directing any executive order. She has the power to do so, and that's why the court then said, by my reading, that that is why governors are typically brought into these matters. It's a common occurrence, the court said. Next, just because, I think I covered that. Just because there's a reporting to the board doesn't mean it's exclusive. And finally, any person implementing the challenge law, I was saying when I stopped, should be a proper party under the Richer case, which I'll repeat, that issue was dealt with similarly. And finally, we're not merely referencing a dispute between officials. This is a question assessing constitutionality, not just a debate between officials.
Thank
you very much.
Counsel, thank you for your presentation today. We appreciate your briefing. We'll take this matter under advisement and issue a written decision in due course. Court is adjourned.